Good afternoon. My name is Daniel Hartman. I'm the president of the Federalist Society here at Mizzou. The Federalist Society is a nonpartisan, conservative, libertarian organization dedicated to fostering free and open debate on the fundamental principles of freedom, federalism, and judicial restraint. On behalf of our chapter, I'd like to thank you for joining us for this discussion on how law and regulation impacts business growth. And I just need to say, for Scott's sake up there, we're going to record this. So during the question and answer session, keep that in mind. I want to point out, we also have one of our distinguished chapter alumni, former Federalist Society guy here at Mizzou, State Representative Caleb Jones is with us. So thank you, Caleb, for joining us. We also have another state representative here, current member of the law school, not a Federalist Society member, but we're working on him, Representative Stephen Weber. Our speaker today is Mr. David Humphreys from Joplin, Missouri. Mr. Humphreys has a BA from the University of the South in Swanee, Tennessee, his JD from the University of Miami, and his LLM in tax from New York University. After practicing law in Missouri and New York, he is now a third-generation leader of his family's business, TAMKO Building Products. Headquartered in Joplin, Missouri, TAMKO is a leading national manufacturer of residential and commercial building materials, including roofing, waterproofing, and plastic composite decking. Mr. Humphreys is involved in 3 enterprise organizations and serves on the board of the Institute for Humane Studies and as chairman of the Acton Institute for the Study of Religion and Liberty. He's also a member of the University of Miami Law School Visiting Committee and former chair of the Board of Regents of the University of the South. In 1993, Mr. Humphreys and his wife founded the Thomas Jefferson Independent Day School, a pre-K through grade 12 school in Joplin, Missouri. And I know most importantly to him, he and his wife Deborah have 5 children ages 18 to 28. Please welcome Mr. David Humphreys.
Am I on? Okay. So I think the purpose to record this is so that when you ask questions, the drones will be able to find you. So, I was asked to speak today about the impact of legal and regulatory constraints on business and on business growth. And I thought that probably the best way for me to handle this is to tell some stories of real-world experiences that I've had over the course of my career, and not really dwell in the sort of academic side of case analysis. So I'm going to try to talk to you about how these things cause serious challenges for business and for society, frankly, and pose some dilemmas. So I want to attempt to do that by touching on 2 particular areas, which I hope that you will find somewhat controversial. So first, let me give you a little bit more of my background so you can have some context for my perspective. But before I do that, just a show of hands real quickly. I'd like to know a little about you. How many in here are married? How many have children? Okay. How many work between college and law school? How many people majored in math or science in college? How many didn't? Okay. It's important, I think. How many have worked in legal firms at some point during your time in law school? How many worked for plaintiffs' firms? How many worked for defense? Anybody do any criminal work? Who did prosecution? Who did criminal defense? How many did criminal defense? Okay, a couple. Okay, that's good. All right, how many of you broke the law? Really? Do it again. How many broke the law? I was expecting no hands. I broke the law this morning, actually. Several times on the way to work. I drove 55 and a 35. Now, how many of you have been caught? More than a traffic ticket. Don't raise your hand. All right. Well, that ought to give you some, perspectives of your own and the personal experiences you had. I was going to accuse you of, didn't you remember you went to college? Didn't you remember that you were probably holding it for someone else? Underage drinking or something like that, or speeding, which I'm sure most of you have done one time or another. How many people in here have not ever gone over the speed limit? Ever? Okay. All right. Okay, I graduated in 1983 from the University of Miami in Miami, Florida. I spent 9 months of my time there, as in my third year, into my second year, and in my third year, working at the public defender's office. I was a very proud card-carrying member of the ACLU. So I don't know what you expected to see today, but here I am, all right? And I still like some of the stuff they do. So, after law school, I practiced 2 years in Joplin for an insurance defense firm doing personal injury, products liability, medical malpractice defense. And that was really good experience to understand how courtrooms work, what goes on in a courtroom, what judges and juries are like. And it was a really good experience for me. But I really didn't like juries. I didn't like standing up in front of the jury. I was way too shy for that at that time. And I didn't like the choreography of it. I liked appellate work, but I actually really liked business transactions. So I eventually pulled up stakes and went to NYU, New York City, to go to tax school and get my LLM. And that turned out for me to be a really great decision because it provided me some really interesting opportunities in transactional practice. I ended up at a very large law firm, 400 lawyer law firm, Davis Polk and Wardwell on Wall Street in New York. And that opened my eyes to a lot of the inner workings of business transactions on a very high level. You know, our clients were Goldman Sachs, Morgan Stanley, JP Morgan, some very large Fortune 100 companies like International Paper and Pan Am. And when I was in that practice in the 80s, the leveraged buyout frenzy was going full force. So I left Joplin on the heels of doing a $25 million sale of a business transaction. One of the first things I worked on in New York was an $800 million leveraged buyout. So it kind of was all there. I had the experience of being in a conference room in 1987 when the market crashed 25%. And there's a guy on the other side of the transaction screaming, "I don't care where the comma goes, I've lost millions." And it was just a beautiful moment because he was on the other side of the deal. I also worked on a transaction where United Airlines sold off the Westin hotel chain. And that transaction really helped launch my career. It was about an $8.5 million deal. And as a result of that, I ended up being able to take an appointment to go to Davis Polk's Paris office, where I worked for a little over a year. And so in that office was about a 15-lawyer office, so a much smaller office, but same high-level practice, and advising clients in all over Europe, Brussels, Milan. And I did one deal in Helsinki, where I went to Helsinki to advise this 150-year-old paper company, forest products company, to how to sell its tissue paper business, because they wanted to raise capital to invest in some newfangled technology that they'd acquired, and be able to commercialize it. And so I helped structure the sale of that business to avoid any taxes for them. And it was a company I'd never heard of. And to me, it was like, why are you going to sell this really great business, tissue paper, which is probably going to make money forever? And you go invest in this thing. Because this thing was like, I didn't have one. But the name of the company was called Nokia. So here I was at the headquarters of Nokia in Helsinki, and they're selling off this business. But what struck me then is that these people take risks. And I'm a lawyer. And what we do is we avoid risk. We don't like risk. We do our best to help our clients not have those risks. So the business is in fact about taking risks. So you kind of have to learn that balance. And then after I returned back from Paris, my father came to town and asked me if I'd consider coming back and work for him, which I had never thought of doing, because he'd always told me to go find a job. But he made an offer I couldn't refuse. He said he'd cut my pay 60% and let me work at home. So that was great. So I had a choice of Joplin versus Paris. And you can see that it worked out. Anyway, I've ended up serving as our chief executive now for about 20 years, since his death in 1993. What we do is manufacture building materials, primarily asphalt roofing, a waterproofing, and plastic composite decking. And we also produce them of our own raw materials. So we make paper, we make glass fiber, we make glass mat, we make polyester mat, and we process asphalt. And we have about 16 manufacturing plants and warehouses around the country, and not quite 2,000 employees. And so since my joining the company in 1989 as general counsel at that time, I've seen over the course of my career a tremendous growth in all kinds of regulations that we've had to deal with. And in particular, employment law issues and employment law mandates, as well as environmental regulations and mandates. Now, I know that Daniel, I gave him a big stack of articles, reprints. You hand those out, maybe in the back. It's a reprint from a magazine called the Society of Compliance Officers, Executives. And it's an article about our compliance team, myself, our general counsel, and my compliance officer, who is also a lawyer, former prosecutor, former consumer products guy in the Attorney General's office. But our philosophy on compliance is pretty simple. And it kind of illustrates, I think, what business has to deal with in navigating the regulatory world. We basically use a metaphor of football, and that we try to play between the hash marks. Because in the hash marks, you're away from the boundaries. The lights are the brightest out there. And so it's pretty clear where you are. The other thing is you can end up in the real world running down the sidelines and you think you're in. And that's dangerous because, yeah, you're in, but you may turn around and look back and you've been running out of bounds the last 5 years because someone changed the rules. In fact, they moved the sideline in. So if you play in the hash marks, you've got a better chance of not stepping out of bounds. And some of those boundaries are pretty scary because they often carry large penalties or even criminal penalties. And even worse, you may be required to self-report. So for all of you people who speed, think of it this way. Every time you go over the speed limit by 1 mile an hour, you really ought to go downtown to the police and tell them you did it. That's effectively the world that you're going to end up in someday. It's where you can either self-report or 1 mile over is just as bad as 10. So there's a lot of that. The other thing about the business world and regulations is that the referees often have their own agendas about whether to see you in or out of bounds. It's kind of like the home game. So you really don't want to be playing in these boundaries where the lights are dim, with referees who have a self-interest in the result. And you really want to be out there where everyone can see and say, you know, if he called you out, it's pretty clear you're not, that you can prove that you're okay. So that is how we operate our business, is trying to play between these hash marks. Because life's just too short to call out of bounds. Okay, that's enough about my background in TAMKO. I wanted you to understand our management approach to legal and regulatory risk, and that it's been shaped by both my legal experiences in trial circumstances, as well as in the corporate law practice. So let's talk about how legal constraints and regulation impact a company like ours in a very real way. So the examples I want to share, like I said, may be controversial, but that's because they tend to be emotionally charged. They are dangerous to you financially, they're dangerous to you politically, and they're dangerous reputationally. It's really for any business or any business executive. So having said that, let me say, I'm not here to argue against these regulations. I'm just here to talk to you about the fact that they're here and they cause these dilemmas. Okay? In fact, I'm not opposed to most of this. I mean, for the most part, they stem from good intentions and they intend to prevent or punish bad behavior. And in general, that's okay. But the practical aspect of dealing with these things is not as clear-cut as you might think in reality as it may appear in theory. So there are also the issues which make things even cloudier, where you have the decision as to what the right thing to do is affected by not only the facts, but also who's involved, who are the parties, and also who is making the decision of right and wrong. Is it this judge, or that judge, or this set of jurors or that set of jurors? What are their perspectives? Where have they come from? What are their life experiences? What are their own personal biases? All of that just adds a huge amount of uncertainty to how business has to adapt to regulatory risk, because you want to stay away from these boundaries. You don't want to be out of bounds. So if there's too much uncertainty, typically the answer is you do nothing. You do nothing. So you don't take that risk. You don't buy that manufacturing plant that happens to have on it a big pile of something that you don't know what it is, that was left there 60 years ago. Because God knows how much it's going to cost to either cart away or close in place, and who knows what the groundwater issues are going to be, or what the contaminants might be in that pile. Particularly if the seller doesn't want you to know. He's not going to share that with you. So what happens? You just don't do it. So when you have that kind of legal uncertainty overhanging a transaction or decision, typically risk avoidance takes over and you say, no thank you. Okay, here goes. Don't throw anything at me yet, all right? Give me a chance. I'm going to talk about two hot buttons. And they're both hot buttons, but business faces this stuff all the time. The first one's going to be racial harassment. Racial harassment claims. That's a very dangerous claim. It's an emotionally charged claim. And it should be this way. And I'll tell you a story about our experience with that and show you the dilemma that we were in. We have a plant in Tuscaloosa, Alabama, where we had a supervisor who was accused by an African American employee of having used the N-word in a conversation with him. Now we investigated this and found out that in fact it did happen. He said, yeah, I did it. I'm sorry, I only said it for fun. And the other piece of the puzzle was that the complainant wasn't reporting it because he just remembered it or because he just screwed up the courage finally to tell us about it, but because it's been passed over for promotion, completely unrelated to this. So that's the fact pattern. So what would you do? What would you do in terms of remediating the situation? This is a question for volunteers. Is this too hot for you guys to handle? Anybody? What would you do? What would you do with the supervisor knowing these facts?
And I deal with both issues separately. So you've got the job performance passover and you've got the racial discrimination, the word. But I might deal with them both separately and not tie them together.
Okay. Well, we have a racial harassment policy. We have a gender harassment policy. We have a harassment policy that covers lots of things. It says, don't do this. Okay, so he's violated our policy. We just found out about it. What do? You've got a variety of choices. Okay, we'll do this show of hands. Okay, how many would call him in and sit him down? That's at least a start. Okay. How many would give him an oral reprimand only? How many would give him a written reprimand in his file, permanent file? How many would suspend him for some period of time? How many would terminate? How many terminates? Okay. 1, 2, 3. All right. All right. So let me tell you what we did. We pulled him in. We counseled him not to repeat this behavior. We suspended him. We issued a written reprimand in his permanent file. We made him attend remedial training. And really the reason for that was, the reason we came to that conclusion was it happened 2 years ago. It just got reported to it. There was no corroboration. It probably happened. He admitted it happened. It was bad behavior. It violated our policy. But it was 2 years ago. There's been no continuing circumstances. And we're unaware of anything else. So we thought based on that was sufficient to correct and punish the bad behavior. Well, he didn't think so. And so he filed a Section 1983 action. Anybody know what that is? Racial discrimination action. What's it also have with it usually? 1981? It's the punitive damage claim. Okay. All right, so we ended up with that. And we have 2 other complainants who decided we have a hostile work environment. So, We believe we had a very defensible case, as we had a written policy against this conduct. We disciplined it as soon as we learned of it, like the next day. We had had no report of any other bad conduct on his part or anybody else's. And we had a policy of report. We had a way to report without any interference from the supervisor. So we were assigned to a judge. We're in federal court. We're assigned to a judge that we perceived as very liberal and very plaintiff friendly. Okay? So, does it matter who the judge is as to how you're going to do? See some nodding heads? I mean, should it matter? Do you worry about who appointed him? What's his track record? What's his background? Who he is? Yes, you do. We felt like we'd done the right thing. And so we pursued a very vigorous defense, and we conducted several mock jury trials. And those are called pretend trials, where you kind of roll your case out, you try it real short, and you say, okay, how do we do? What's the answer? We did like 3 of these. We got killed. We got killed. The mock juries are like, you're dead, you know. And after doing that, we're like, wow, okay, and again, it doesn't matter who's on the jury. And we just didn't go down and pick like you. We actually did demographic studies of the area, and what the typical juror pool is going to look like. And we tried to put people that look like that in this pool so we get a representative feel for what was going to happen. And that's done. I mean, people do this stuff all the time. You kind of want to say, what do we do? What worked? What didn't work? How do we craft this case? I mean, you're putting on a performance. You want people to clap. So after a couple of mock jury trials, we decided that we're going to lose. And the single reason told us by these mock jurors was that you didn't fire this guy. You should have fired this guy. Okay, so only 3 people in this room gave me the right advice for this case, all right? We didn't fire this guy. Yeah. So they were all fixated on that. So it was deemed irrelevant. It took 2 years. It was deemed irrelevant. We had a policy against it. It was deemed irrelevant that the guy might have made an honest mistake in judgment or just said something stupid. So what do? Settle the case. I don't like settling cases when I think we're right. This is one like, we're not going to win it. So trying that case wasn't worth the risk of a substantial judgment, punitive damages, potentially catastrophic, reputation damage. We decided it wasn't worth the risk of trial, despite the fact that we really felt like we'd done everything possible to prevent it and remediate it. So, as a result of these insights newly gained from these mock trials, we changed our policy. We changed it to a no tolerance policy. You do this again, anybody does this, first time, you're gone. First time, you're gone. You make this mistake, you're gone. Doesn't matter why you did it, what happened, doesn't matter, you're gone. The remediation was just no longer viable. It was obviously too high a risk to take to have a remediation strategy, policy to deal with this kind of bad behavior. So, again, playing within the hash marks. If the boundaries get squeezed in, you move your hash marks in too. That's effectively what we do. So, laws and regulations cause us to try to comply in an uncertain world, but the expansion of uncertainty by judges and juries does the same thing. When you learn something like this, you adapt. Now, I will tell you, the change in policy, and frankly, those kinds of policies achieve good results. It drives out racist behavior, which is a good thing. But it comes with some collateral consequences, sometimes unpleasant ones. And that kind of death penalty, no tolerance policy has collateral consequences, which I'll talk about in a little bit. The more interesting part of the story happened almost at the same time during the pendency of the 1983 case. We had changed our policy. We began retraining, starting in Tuscaloosa, where this took place, that we would not tolerate this kind of behavior. So we went through that. About a week after that was completed, an employee went out and called somebody a name, racially charged name. Okay, so now, what would you do? What would you do to this guy? There's no choice. You got it. Your policies, you're gone, right? Okay, you're gone. And he knew this. So we terminated him for violating our policy. And he was a union employee. They filed a grievance saying this is too severe. And so with the union employees, you go through a grievance procedure. Then if you don't agree, eventually, you go to an arbitration, which is sort of like a bench trial, mini trial, and you get a decision. And so we did that, and the arbitrator came back, the employee admitted to making the comments, there was no dispute of the facts. The arbitrator said, it's too severe, you need to take him back. You need to take him back and give him back pay. Okay. So I asked our outside counsel what we should do. He said, well, we could appeal to federal court, but you're going to lose. So what do we do then? We found new counsel. I don't think some guy thinks we're going to lose. We hired somebody that believes in us, right? So what we do, we hired new counsel, we went to federal court, we appealed the arbitration decision, we drew in the lottery, we drew the exact same judge in which the 1983 case was still pending. The same liberal judge that we thought were going to get killed. But I'll tell you what, we won. This judge, it wasn't lost on him that in the 1983 case, we effectively were being accused of racial discrimination for not having fired this guy. He got that. Yet in this other case, we were up in front of him trying to overturn arbitration. We were accused of firing someone for the same thing. So what do? Do you fire him or do you not fire him? Either way, you're losing. So anyway, the judge ruled in our favor and upheld our termination. The union appealed that to the 11th Circuit. And also during this time, the union was decertified, so they're no longer in place, but they're still representing this guy. So they appealed the 11th Circuit. The 11th Circuit says, so severe, if he needs a job, you really need to take him back. You can do anything to him except fire him. That was the decision in a nutshell at the 11th Circuit. So it gets remanded. And of course I figured, well, we can do anything to fire him. I can work with that. We'll figure something out. So it gets remanded to the federal judge. Federal judge imposes back pay. We appeal that, but he didn't have jurisdiction. It goes to the 11th Circuit again. They agree with us. It goes back to the arbitrator. The arbitrator dies. It's a true story. I'm not making this stuff. It's all true. It's all true. The guy dies. So while they're getting a new arbitrator, we impose our discipline on this guy that we're forced to take back. The discipline is the most severe discipline you can imagine. Public speaking. We made him write an apology, and then the deal was he was going to have to stand up in front of 200 people in this factory and read his apology for his behavior. He could never get it done. He walked out. So that was kind of a good result there. But we ended up spending altogether about $500,000 between the back pay we had to pay and about $400,000 in legal fees to prosecute that case, to take it up on appeal twice, to do all the other stuff. And we could have just folded after the arbitration and spent about $25,000. But we fought for what we thought was the right thing to do because we believed, A, he did something wrong, and B, the discipline we imposed under our policy, he knew was coming, and it was fair. So, but doing the right thing has a high cost sometimes. But you can see there's a dilemma sometimes into how things are interpreted depending on who the parties are and who the judge is and second guessing of decision. So when we back off for a minute and talk about the collateral consequences of going to a sort of death penalty no tolerance policy that we did in order to protect ourselves from future claims. Now, what we figured out in this process is that the climate of public opinion is one where, when it comes to eliminating bad behavior like racial harassment or sexual harassment or any of that stuff, environmental misconduct, same thing. The public and the regulators want somebody's head on the platter. That can be the bad actor, it could be his boss, it could be the employer, it could be the company, or it could be a bunch of heads. Okay. So when you look at your options as a business, you're going to take the safest course. You're going to take draconian action, turning every offender, regardless of the individual facts and circumstances. Or you're going to risk paying a high cost of legal fees and potentially large damage awards. So, in that regime of no tolerance policy, I can guarantee you, because I've seen it, bad behavior disappears pretty quickly. It is very severe. Okay. If we cut off your right hand every time you went 1 mile over the speed limit, you would quit speeding. In fact, you'd quit because you didn't want to lose your other hand. All your friends would quit right away. Okay, it's that sort of severe thing. So there's a real human cost of this. But we had a subsequent incident which really encapsulated how draconian this is, how it protects us, but yet it has such a huge effect, which is really unfortunate that we're not really able to feel comfortable going a remediation route or a less than termination route on certain kinds of offenses. We had an employee who had been with us about 16, 17 years. He had about an 8th grade education. He was not well educated. He was not real smart. And he told a really stupid racial joke in front of a group of people, including an African American employee. He got reported, not by the African American employee, but by somebody else, and we terminated him. This man was making about $18 an hour in a factory job as an unskilled laborer, which with overtime works up to about $50,000 a year. The next best factory level unskilled job in Joplin at that time was about $12 an hour. So basically the cost was he lost his job of almost 18 years. He took a 1/3 cut in pay for telling one stupid joke. But that's the result of what business has to do these days to protect itself from having these boundaries shift around. And that's a really unfortunate thing for someone like that. And there have been a couple like that that are really unfortunate. But I can tell you, we don't have any incidents anymore. They're gone. But there's a very high cost, personal cost to people for that as well. But that's kind of what's required to play within the hash marks. Let me tell you a little different story about on environmental. Let's shift to environmental. Environmental is another hot button for business. Because environmental, you step into something, you can explode in terms of cost and money and expense. We have a factory located between Baltimore and Washington, D.C. And we determined we needed to add a second driveway into that plant. Is this a blackboard somewhere here? Oh, cool. It's got chalk. That's great. Okay. So we had a factory out in Maryland, and we wanted to put a new driveway entrance into the factory. The factory's back here, and we wanted to put it down here, a brand new entrance, because occasionally we'd have so much truck traffic coming into this side it would back up into the public street. So we wanted to be able to alleviate the traffic and get them off the street by getting the employees all over here and all the other vendors on this side. So we had originally purchased this whole tract in the 1970s. And it had a highway, had a good entrance here, and this was all of our property. This was our entrance into the factory right here. And sometime subsequent to that, the county decided they wanted to put a public road through here to connect up to some other developments. So they condemned this, stranded this property over here on the other side from us, from our use. And so to provide a little bit of a buffer against the public and the public view and public road, we planted some trees in here. Nice trees, they're about this big around, they had a scrub brush, but they were enough to put a little buffer between us and the roadway. So about 20 years later, we're wanting to put this driveway down here on the end of the plant. And so the permitting process for environmental things is quite complicated sometimes. We had to get permission from the state, from the county, and from the city. And the process itself took about 2 years to get everyone to agree that we could put this driveway and run it in over here and put a parking on it. So they issued a preliminary permit for us to comment on before it was finalized. And by comment, I mean agree. Here it is, agree to it. And the preliminary permit required us to mitigate the effect of bulldozing these trees on our way into the property. And they wanted us to pay a fee in lieu of of replanting trees. We can either go plant them somewhere and buy the land to do it, or we could buy reforestation credits. So the fee in lieu of is going to be about $1 million. Because what they did is they calculated that, now we were going to basically bulldoze about an acre worth of trees, but we had about 20 acres worth of trees here. So our potential to affect these trees was 20 acres. So they wanted to charge the 20-acre fee. So we argued over that quite a bit, and we hired local counsel to help advise us there. He told us there was nothing we could do. So what did we do? Got new counsel. Right, okay. We hired them. We had a decent argument to try to contest the fee. We ended up having to agree to pay $100,000 for this. Otherwise, we're not going to get the permit at all. It's still hard to believe that we had to not only get permission to cut down the trees that we planted, but we also had to pay to cut them down. And if we hadn't planted them in the first place, we wouldn't have to do anything. So the deforestation regulations and the environmental regulations covering this issue weren't in existence in 1985 or 1975 or 1985. This is an example when the boundaries change after the fact and something happens. And it's also a good example of the effect of regulation because it raises the cost of doing business both financially and in terms of time, opportunity cost. And the footnote to this project is that we never did it. We never did the project. We got so caught up in this, it took additional time, additional effort. It was going to cost $100,000 more. It was a very expensive project anyway. And with all the uncertainty and the delay and the cost, we just kind of got bored and went on other stuff. So it never got done. So whatever contractors would have worked on that project never got to do it. And so the uncertainty, delay, and the cost are part of the effect of a highly regulated society. So what's the effect of that? What do businesses need to do? They need to hire more lawyers, which is good news for you, because it takes a lot of lawyers to tackle these kinds of problems. And it takes a large commitment for a business like ours. When I came to TAMKO, I was the only lawyer. My responsibilities were primarily reviewing contracts, overseeing insurance coverage. That's kind of it. Environmental issues were straightforward. They were sort of engineering-based. The employment-related issues were related to racial discrimination. We didn't have any issues. I was the first and only full-time lawyer in-house in 1989. Today we've got 8 in-house lawyers, a couple paralegals. I have another former lawyer doing project work. My number 2 guy is my former general counsel. He has about 2/3 of the company reporting to him. So altogether about 11 of us with legal training. And most of our time is spent in preventative risk assessment and risk mitigation, like policy crafting and oversight. And we have oversight in every single employment decision. With multiple plants and multiple locations, with different managers in all those locations, we want to have a consistent policy among all those locations because we don't want to have that risk that someone does something stupid or that they don't follow our policies because they feel sorry for this guy or that guy. It's also more difficult, frankly, for managers at a site to look a guy in the eyes and say, I'm sorry, I'm going to have to terminate you. It's the difference between stabbing a guy and shooting him with a sniper in the way in the back. It isn't as personally painful, so it's somewhat easier from a distance to do that. But it's unfortunate. The expansion of employment regulation penalties require us to have an even more rigorous review and oversight of all our employment decisions. The same thing is true for environmental. We have environmental managers at every facility. We have an environmental department with several people there in specialty areas for environmental. And they help protect us and our company from legal and regulatory risks, but they're not productive projects. So let me close on just a couple of things. Let me say this to you this way. Where do laws come from? Where do regulations come from? Okay? They come from people like you. Okay? Basically, well-educated, white-collar, lawyers, politicians. Okay? That's what you guys did, right? All right. But, okay. You're educated. You're sophisticated. All right? You're intellectually inclined. What I've seen is a profound, disproportionate impact on the uneducated, the undereducated, the uninformed, the less sophisticated, and the less fortunate. You know, the people, in many cases, these laws and regulations were designed to protect. Now, I don't just mean the poor guy who told the stupid joke that we had to fire him too, all right? But everybody else, okay? Any person whose conduct or job performance could put us at risk of regulatory infraction or legal overstep, they bear some cost in some way. I mean, risks like on-the-job injuries used to be quantifiable in a workers' compensation world, but that's all been expanded to a much broader scope of liability these days. Workers' compensation originally was set up in exchange for employers giving up all their common law defenses like retributory negligence and fellow servant rule stuff in exchange for strict liability, but a defined quantifiable benefit to an employee. And he got that benefit for sure, it was strict liability. Well, that's still there, and now we've got expanded liability on the tort side. And claims for racial and sexual harassment, the more employees you got, the more risk you got. So, in environmental, same thing. You got people, if they have to go turn a button or push a button or turn a valve off or do something to change a process to make sure it's environmental compliance, you have to depend on these guys. And you have to depend on their mistakes. At the end of the day, what you end up doing is automating as much of that stuff as possible, so you need fewer and fewer employees. And that's one of the reasons that employers like us, I think you see this broadly across the states right now. You hear about sort of all these disappearing jobs. Yeah, some of them went offshore where those liabilities don't exist, but I think the vast majority of those are being automated out. So you have very low-skilled manual labor jobs that exist, and you have very high-skilled, intellectual, driven jobs, knowledge-based jobs. But these guys in the middle that used to turn knobs and work in factories are seeing their job disappear because, frankly, the cost of having them there has gone up and up and up. And so it's much easier to automate and much safer to automate, which is in some ways too bad. So, you know, robots don't take bathroom breaks, they don't go on vacations, they don't go to lunch, they don't complain, they don't need training, they don't need health insurance, all that stuff. And we also have a chief compliance officer, and the article that's in that magazine we handed out is about him and how he manages compliance. So in addition to all the people we've got a compliance officer over all of that to make sure the people who are supposed to be making sure everything happens do it. And so additional layers of cost and layers of controls to make sure. So let's do one more thing here. How many of you guys have seen the guy in the corner with the sign who says, "We'll work for food"? You seen that guy? He's everywhere, right? How many of you have actually hired him to go anywhere with you to work? How many of you just give him $10? Couple. Okay. Well, let's think about the value of work. Okay, is it better for me to give him $50 or to take him home and have him mow my lawn and do something valuable, that recognizing he's a human being and that there's value in work and dignity in work and he'll earn his own keep and all those things, as opposed to here's $10 and leave me alone? Okay. I'm going to have to get an I-9 to prove he's not a foreigner, all right? He has a legal right to be here. I'm going to worry about withholding tax because I'm in a situation where I'm going to have to pay withholding tax if I take him home and he does these things. I'm going to worry about the fact that he's not on my workers' compensation policy, so that when he falls over or runs over his foot, I don't get sued. All right? And, you know, all those things. And when he's done at the end of the day, gee, is he entitled to health insurance? Has he been wrongfully terminated? And what are all the risks that I've got? So when you make that sort of calculated decision, you might as well just hand him the $50 and go on. It's cheaper than all the bureaucracy and the red tape you have to go through to hiring. Now, how many of you have kids? Some of you guys have kids? How old are your kids? Are you young? Old?
No, mine are a little over here.
Okay. Older than mine. Wow. Well, they don't need babysitters. How many of you have had babysitters? That's the way I'll ask the question. How many of you have babysitters? Okay. So you pay them and you withhold, you file unemployment or FICA forms. They work for you very much. Same babysitter every night, every year. And you pay more than $500 in a year. You send them a 1099. Okay, so you broke the law too. I mean, these are all the things. I mean, if you really get into this, I mean, you're never going to be a federal judge because they're going to find this out. Okay, they found that you didn't properly withhold. So, you know, all these little things are headaches, and they cost money, they cost time. They're not clear. That's the other piece of this thing. The answers are not clear. And so it's just not as simple as do the right thing. Sometimes the right thing is what your opinion is and what your opinion is, and they're not the same. So those are sort of the insights I wanted to provide to you today, is that these things are gray areas, they're cloudy areas. Businesses, I think, generally try to do the right thing, believe it or not. I'm sure some of you walking in here today, despite the fact this is the Federalist Society and not my home chapter of the ACLU, you start off with the first question the lawyer asks on cross-exam, which is, isn't it true? No matter what you say, it doesn't matter, you've done it. Isn't it true you're a businessman? Isn't it true you work for a corporation? It's a bad word, right? Isn't it true you want to be implemented? I mean, that's the environment a business walks into when they're judged. And so you have to really try to have your ducks in a row, because if you don't, you're going to walk into a very anti-business climate in any regulatory scene or any jury trial, and sometimes with the judges. So that's it. Questions? Yes, sir.
What do you think it costs you per person to stay compliant every year?
I don't know. I got 8 full-time lawyers, 1 compliance guy, 2 paralegals, 6, 8 environmental health and safety professionals, just a corporate, another dozen or 15 at the plants.
And all that's because of these regulations.
Yeah. I mean, since 1989, there's been a tremendous growth in the regulatory world. Employment-related regulation, and by regulation I also mean mandates. You need to comply with the Family Medical Leave Act. Well, that's great, we can do that, but we have to have a system to count days and keep track of vacation and know who's doing this and know who's really sick and have to do. It takes a huge amount of effort just for that. The Americans with Disabilities Act, whole new thing. First of all, you have to understand it. You have to hire lawyers to understand it. The new Health Care Act. You have to have your lawyers tell you what you have to do to modify your health care plans to be compliant with that too. So I mean, the compliance, you're always updating compliance annually. So there's sort of an annual cost of doing that, even if nothing changes, just to make sure you're compliant. So I'm sure it's millions of dollars. How many, I don't know.
Well, thank you very much. Help me thank Mr. Humphreys.